Ask almost anyone what they care about most in this world, and they won't tell you about their bank account balance or the deed to their home. They will tell you about their family. They'll talk about protecting their kids from hardship, keeping peace at the Thanksgiving table, and making sure their life's hard work actually helps the people they love. Yet, every single day, loving families across the country are torn apart by unnecessary arguments in hospital hallways and months of stress in courtrooms. Not because parents didn't care, but simply because nobody sat down to put their wishes on paper. When people hear the term estate planning, they often think of formal legalities or end-of-life logistics, but getting your affairs in order isn't about dying. It is an extraordinary act of love. It is about locking in your dignity, protecting your care, and giving your children the ultimate gift, complete peace of mind, so they never have to guess what you would have wanted. If you are over 55, if you're 65, your paperwork shouldn't be left to chance or left sitting in a folder untouched for 15 years. Today, we're taking the confusion out of the law. We're breaking down the difference between a will and a trust, how to avoid probate, and the 5 essential legal documents every senior citizen needs. Whether you plan to work with an elder law attorney or review what you already have, this step-by-step guide will ensure your voice remains heard, no matter what tomorrow brings.
Welcome to the medical walkthrough.
So let's jump right into document number 1, your financial power of attorney. Think of this document as your primary financial backup plan. A durable power of attorney is a legal document where you appoint a person that you trust, known as your agent, to manage your financial affairs if you ever become temporarily or permanently unable to do so yourself. Now, a lot of people assume, well, my spouse can just step in if something happens. But legally, that isn't true. If you are recovering from surgery or involved in an accident, your spouse or adult children cannot automatically log into your bank accounts, sell stock to cover medical bills, or manage your real estate held in your name. They can't do it alone. Without a financial power of attorney in place, your family has to go to court and ask a judge to appoint a legal guardian or conservator. That process takes months, costs thousands of dollars in court fees, and puts a judge, not you, in charge of who manages your money. The key here is make sure your document is durable. Durable means the power stays in effect even if you lose mental capacity down the road. Before we move on to document number 2, if you're finding this breakdown helpful, please take 2 seconds to click that like button and subscribe to the channel. It helps this information reach other seniors and families who need these legal protections in place. Thank you so much for the support. I share this information because I've lived it. We lost my dad in 2002, my mom in 2021, and neither had a will or trust. Sorting through their assets and debt without a plan took a huge emotional and financial toll on our family. Getting your affairs in order isn't just about legal paperwork. It's one of the greatest acts of love you can leave behind for your family. Document number 2 moves from your wallet to your healthcare power of attorney, sometimes called a medical power of attorney or healthcare proxy. While your financial power of attorney handles the money, your healthcare power of attorney appoints someone to make medical decisions on your behalf, and only if you are physically or mentally unable to speak for yourself. Imagine you are under anesthesia or experiencing a medical crisis. Doctors need one clear, legally authorized decision maker to talk to. Without this document, family members can get into terrible disputes in hospital waiting rooms over who has the right to decide on treatments or surgeries. When choosing a healthcare proxy, look for someone who stays calm under pressure. You want a person who will honor your personal medical preferences, even if their own personal opinions are different. That brings us to document number 3, a living will, also known as an advanced healthcare directive. While your healthcare power of attorney chooses who makes decisions, your living will lays out what those decisions should be. This document puts your explicit instructions in writing regarding end-of-life medical care and life-prolonging treatments. In a living will, you address specific scenarios. Do you want mechanical ventilation if there's no chance of recovery? What are your preferences on artificial nutrition and hydration? In other words, feeding tubes. Do you have specific do not resuscitate directives? What are your wishes regarding comfort care and pain management? I know these aren't easy topics to think about, but drafting a living will is actually one of the greatest gifts of love you can give your family. When a crisis happens, your loved ones won't have to carry the emotional burden of guessing what you would have wanted. They can simply point to your written words and say, "These are my mom's or my dad's wishes, and we are honoring them." Now, I know we are covering a lot of details today, and it can feel overwhelming to keep track of what paperwork you have and what you still need to update. So to make this easy, I created a free estate planning checklist. It's a clean, step-by-step PDF you can print out at home to audit your current documents, track dates, and bring directly to an estate attorney. You could download it right now for free by clicking the link in the top line of the description box below or by going to the pinned comment. All right, let's talk about document number 4, the HIPAA release authorization. This is one of the most frequently overlooked documents in an entire estate plan, but missing it causes massive headaches during emergency care. So HIPAA stands for the Health Insurance Portability and Accountability Act. It's a federal privacy law designed to protect your private medical records. Now, while that privacy is a good thing, HIPAA laws are so strict that doctors and hospital staff face severe legal penalties if they share information with unauthorized individuals. Now, here's what happens in the real world. You're admitted to a hospital, and your adult son or daughter calls the nurse's station from out of town to check on your condition. But without a signed HIPAA release on file, the hospital staff is legally forbidden from giving them even a basic status update. A simple standalone HIPAA release names the specific family members or friends who are allowed to receive medical updates and review your charts. It doesn't give them authority to make decisions. It simply grants them access to information so they aren't left in the dark, especially during a medical crisis. Now we arrive at document number 5, deciding between a last will and testament versus a revocable living trust. Both of these documents serve the same core purpose. They dictate who inherits your money, your real estate, and personal belongings after you pass away. But the way they accomplish that goal is completely different. So let's start with a will. A will names an executor to oversee your estate and list who gets what. However, there's a huge misconception about wills. A will does not avoid probate court. In fact, a will is literally your instruction letter to the probate judge. Probate is the court-supervised process of distributing your assets. It can be lengthy, often take anywhere from 9 months to over a year. It incurs court fees, and because it goes through the court system, it becomes a matter of public record. This is where a revocable living trust comes in. When you set up a living trust, you transfer ownership of your major assets, like your primary house, bank accounts, or investments, into the trust. You remain in total control as the trustee while you are alive, But when you pass away, your successor trustee steps in and transfers those assets directly to your beneficiaries without ever stepping foot in a probate courtroom. A living trust keeps your financial affairs private. They save your heirs significant court fees and is especially valuable if you own real estate in more than one state. Now, before we wrap up, I have to share a critical bonus tip that trips up thousands of seniors every single year: beneficiary designations. Did you know that accounts with pay on death, POD, or transfer on death, TOD designations like bank accounts, 401ks, IRAs, and life insurance policies completely override whatever is written in your will or trust? Let me give you an example. Say you write in your will that all your assets should be split equally between your two children. But 15 years ago, you listed only your eldest child as the designated beneficiary on your primary bank account. When you pass away, the bank is legally required to hand that entire account over to the eldest child listed on that account form. The terms of your will won't apply to it at all. So as soon as you finish watching this video, pull out your financial accounts and review your listed beneficiaries. Make sure those account designations match your current estate planning wishes. Getting these 5 documents in order: your financial power of attorney, your healthcare proxy, living will, HIPAA release, and will and or living trust is not about preparing for the worst. It's about locking in your independence, protecting your assets, and giving your family total clarity. If you haven't reviewed your documents in the last 3 to 5 years, now is the time. Don't forget to grab your copy of my free estate planning checklist using the link right down in the description box below or in the pinned comment. It's a simple tool to help you organize your paperwork today. If this video brought you value, please give it a like, subscribe to the channel, and share this video with a friend or family member who might need to hear it. Thank you so much for watching, and I will see you in the next video. Blessings.
Download your copy of the Patient Protection Blueprint now. Click the link in the description for your copy.